Hi, my name is Benjamin Lee, and I just want to welcome everyone. It is now 1 p.m. Eastern Time, so we'll begin our presentation shortly. For help during today's webcast, please feel free to type your questions in the chat box found in the webinar toolbar to the right of your screen or call 1-800-263-6317. For content questions, please feel free to type those in the question box and we'll be able to answer those at the end of the presentation during the question and answer session. Here is a list of sponsoring chapters, divisions, and universities. I would like to thank all of the participating chapters, divisions, and universities for making these webcasts possible. These are the list of upcoming webcasts. To register for these upcoming webcasts, please visit utahapa.org and register for your webcast of your choice. We're now offering distance education webcasts to help you get your ethics or law credits before the end of the year. These webcasts are available to view at utahapa.org webcast archive. To log your distance education CM credits, go to planning.org, select activities by provider, select APA Ohio chapter, then select distance education and select your webcast of your choice. Follow us on Twitter or like us on Facebook for more information. And we also upload the previous presentations on YouTube. Search for Planning Webcast for more information. To log your same credits for attending today's webcast, please go to planning.org and select today's date, then select today's webcast. This webcast is available for 1.5 CM credit. We are recording today's webcast and it will be available along with a 6-slide per page PDF of the presentation at utahapa.org webcast archive. And at this time, I would like to introduce Stephen, who will be introducing our presentators today. We're having some technical difficulties. We'll get back shortly. Thank you.
is we have five. Okay. We have five commissioners. They're all appointed by the President of the United States and confirmed by the U.S. Senate. The President also selects one of the commissioners to serve as chairman. Only three of the commissioners can be from one political party, and generally the chairman is the same political party as the sitting president. All the commissioners serve for 5-year terms. By organization, we have several bureaus with individual offices underneath, and they include consumer and government affairs, enforcement, media, public safety and homeland security, wireless telecommunications, and wireline competition. For the purposes of what we're doing today, the ones that are most important for our discussion are media, public safety and homeland security, wireless telecommunications, and wireline competition. The majority of the FCC employees are attorneys, and we also do have some engineers, economists, a wide variety of professional and non-professional support staff. I'm the only cultural resource person or historian here at the agency. Soon we'll have a biologist to help us with the impacts of some of our communications towers, taller communications towers, on avian species. We also have an Office of Native Affairs and Policy, which is housed in our Consumer and Government Affairs Bureau. The work that I do is that's Federal Preservation Officer, is across all the agencies. We have a number of ways of licensing nationwide carriers for wireless communications. The majority of the commercial licenses are issued by the Wireless Telecommunications Bureau, where Jeff is one of the managers. These are the nationwide carriers, the small regional carriers, all those folks that allow your cell phones to operate. The vast majority of the licenses that they have are geographic licenses. They can operate in any kind of a regional market. So Verizon, AT&T, T-Mobile, Sprint, US Cellular, Frontier all have licenses to operate in a market, say, northern Wyoming, and they can cite their licenses or their towers anywhere within that geographic market. They have authority to do that with. We also have Media Bureau licenses. Those are the AM and FM radio stations, all the TV stations, all receive their licenses from the Media Bureau. These are site-specific licenses. And this is real important for local planning purposes. The commercial wireless licensees have some flexibility in where they can site their towers, or the broadcasters, and also this will play into public safety. Those licenses are fairly site-specific, and they don't have much flexibility in where they can be cited. The public safety and homeland security, they're the ones that issue all the licenses to the police and fire departments. These licenses are again, site-specific. Because of the nature of their licenses and systems, public safety, the police and fire departments have much less opportunity to move their towers around. They need to make sure that they coordinate their sites and their frequencies with adjacent jurisdictions. So, and they also, like as with the broadcasters, they tend to be slightly taller towers. And then with that is a sort of a basic introduction to who we are. With that, I'll turn it over to Tim. And this is down there. Let the laptop across there. Yeah.
Okay, so again, this is Tim Stelzig speaking now. And what I was going to do is just talk briefly about 3 separate proceedings that the Wireline Competition Bureau has been working on in the last couple of years that have more impact with local issues and some of the other stuff the FCC or the Wireline Competition Bureau does. So the sorry, Harrison. So the Wireline Bureau again, traditionally has regulated any sort of communications that goes over wires, most notably telephone type services, also data services. Today, in a world where pretty much anybody who wants a sort of landline telephone has one, and fewer people do. Our highest priority these days is broadband. So there approximately 19 million people in the U.S. Don't have broadband available to them at their home. And sort of adoption is somewhat a separate issue, but roughly a third of Americans don't currently subscribe to broadband in their home. So it's definitely a focus and priority for us. So the first issue is just put all this up on the screen here, is the Universal Service Fund. So and just at a high level, so what that is it is an explicit support mechanism that takes money from areas that are sort of relatively easy for providers to serve, and it funnels it to areas that are especially expensive for providers to serve. So in sort of back in the days of Ma Bell, the way this worked is that some divisions would, sort of in the high-cost areas, would charge very high fees to other divisions of the same company, and there'd be these subsidy or cross-subsidization within the company to make sure that everybody in the U.S. basically paid more or less the same rate for phone service. After Ma Bell broke up, that it was, instead of just different divisions of Ma Bell, it was different companies charging each other relatively high access rates. And so long-distance rates were high, local rates were low. And what the FCC is trying to do at a real high level is move away from these implicit support mechanisms to explicit support. And so that, where the goal is still for folks to pay relatively low rates for local telephone service, but to the extent that there are parts of the country where where providers aren't able to, where it would cost like $1,000 a month or whatever to provide phone service, the goal has been to use an explicit funding mechanism, i.e. the U.S. Universal Service Fund, to sort of accommodate that or make that happen. So in the slide you're looking at now, there's basically 4 programs the FCC has that are related USF. I guess in the box, in the 4 boxes that go across the the right side, there's the high cost program, which takes money from basically from urban areas and makes it less expensive for providers, or less expensive for providers in rural areas to provide phone service. The Lifeline program, which is for low-income consumers, so it's basically a subsidy to low-income Americans. The E-rate program, health services for schools and areas, and then the rural healthcare program helps support the telecommunications costs of rural healthcare providers. So the reason to go through this currently is that or in this talk, is just to show that in the past year, the Commission has modernized all 4 of these funds, which I didn't do it, but it was a huge lift, and it occupied a lot of resources here at the Commission. And each of these has now been modernized to include explicit support for broadband. So states also have USF funds. So the FCC, which regulates just interstate and international service, it pays for, helps pay the cost for these services, again, just from interstate funds, and states have their own funds. Sorry, I'm messing with the slides here. Just one quick note here is that so to the extent the FCC is funding any services, it imposes service quality obligations on providers. So for example, the high cost fund, fund recipients need to provide a broadband service that basically is 6 megabits down, 1.5 megabits up, low latency, so you don't get jitter if you're trying to use Skype or something like that, and that has apologies. then the and usage caps. That was the third point I want to mention. But usage caps that are similar to those in urban areas, so which currently are like 250 gigs per month, something like that. So the and then the there's also reporting requirements and stuff like that to make sure that there is to minimize the risk of fraud. So and states help. So those reports also go to the states, which helps the FCC oversee the USF fund and again minimize fraud. So a second topic at a high level is pole attachments. So the again, just starting at a real high level, the telephone poles, I'm sure most of you are familiar with, are basically an essential input for broadband services. They, given the sort of the economic unfeasibility of undergrounding facilities in all areas, the only way for broadband providers and telecom providers to get to their wireline telecommunications providers to get to their end user customers is over telephone poles. And often in many in the areas sort of bounded by the footprint of many providers, there's one or just a couple of owners of poles. And in some areas the incumbent local phone company might own just as many poles as the electric utility company, and in that case, the market pretty much works out a trade. But in other areas where the for example, a utility might own all of the poles that the broadband providers need to reach customers, there's definitely potential for monopoly type of uses. So Section 224 of the Act gives the Commission the authority to regulate the rates, terms, and conditions of pole attachments, and also to enforce that, and adopt enforcement proceedings to make sure that there's no abuse there. The way it operates is that the FCC has authority only to the extent that a state doesn't itself assert authority. So it's reverse preemption, and to the extent a state certifies that it desires or it is regulating the pole attachments within its jurisdiction, the FCC rules don't apply in that state. And I think currently there's about 20-something states where reverse preemption has been applied, and so the so state rules apply in those contexts, and the FCC's rules do not. So in April of last year, the FCC adopted an order that revised our pole attachment rules. We took a lot of inspiration and sort of guidance, I guess, from what various states have done in this area. And excuse me, at a real high level, sort of what the Commission has done is, let me just put all this up, is it adopted timelines for access to poles and pole attachments, or for pole attachments, sort of setting out very specific timelines by which sort of a survey needs to be done, or when an estimate would need to be in, an amount of time for the attacher to either accept or reject the estimate, and then a period of time for the make work. And so historically, the way the Commission had regulated pole attachments is to basically allow providers and attachers to negotiate between themselves. And given the sort of imbalance of power that sometimes is present in that context, and the fact that these were being sort of enforced on a case-by-case basis, it wasn't a it was a system that lends itself to abuse. And so partly through adopting the timelines for attachments, and then also imposing other requirements like the fact that any denials now must need to be explained with specificity, and the adoption of self-effectuating remedies, whereby if the pole owner doesn't complete the attachments within the prescribed time, the attacher is allowed to put up their own attachment and pay for it using third-party contractors that have been pre-approved by the pole owner. So things like that have streamlined the access to polls, reduced the time, reduced the cost for sort of all providers, and to the extent that they're self-effectuating remedies, it's gotten the federal government doesn't need to be involved in the day-to-day sort of interaction between providers. So we also basically reduced the rate for some attachers, which will help promote broadband deployment, and clarified, and this is sort of important, especially for the other people in the room, to clarify that wireless providers have access to the pole top, and that any rules that would categorically prohibit pole top attachments are not permitted, and that applied the timelines also to wireless providers. Sort of another proceeding that sort of relates, and I'm going to blow through a bunch of slides here in the interest of time that covers what I just went over. Apologies while I get the slides up to where we are. So, in another proceeding relating to infrastructure access and broadband, also last April, the Commission started a proceeding relating to rights of way and wireless facility siting. So, the goal here is to find ways for the FCC to work well with state and local communities to minimize any, I guess, hurdles to accessing rights of way and to streamline access to infrastructure for wireless facilities. So at a high level, what the proceeding was looking at, so we were seeking data from anybody who was willing to or interested in commenting, trying to find sort of incidences of best practices in the market, areas that had already found ways to streamline access to the rights of way. We're trying to get a sense too, at least on the wireline side, of the extent to which there are actually widespread problems for providers getting access to rights of way. We've certainly over the years have had a lot of anecdotal type stories about particular communities that were perhaps problem communities from a provider's perspective. And we didn't have a good sense as to whether that was just a couple of communities here and there, or whether there was a widespread problem. So the proceeding was also trying to inform us in that regard. And we were, looking for suggestions for things the Commission, the FCC might do to sort of make streamline access in, with these areas. The things that we're looking at, if there are best practices out there, the record is still open. We're interested in, if anybody would like, any of your own communities would like to, make suggestions or anything like that, we're certainly interested in that. The Commission, would consider anything from, adopting rules to sort of educational efforts we might engage in that didn't involve any rulemaking. If we could be involved, it would be helpful for the FCC to be involved in dispute resolution or mediation. That's something we would consider. So at this stage, we are still gathering a record. We're considering different possibilities, and are certainly, welcome any comments you folks might have. So with that, I'll wrap up the wireline issues and turn it over to Jeffrey's going to go next with wireless issues.
We're shifting the computers around. Sorry for any noisy.
All right. Yeah. Thanks, Tim. So now moving on to the wireless side of things. What I'm going to do basically is really two things. First, take maybe 5 minutes or so, just talking about wireless system architecture, how wireless communication systems work, and my purpose in doing that is to give a little bit of background to help understand what are the types of facilities that need to be built out for wireless service, why are they being built out, what are the new developments and new things going on in terms of the architecture that everyone's dealing with. And then after that, I'm going to talk about the statutory provisions and the FCC policies that have a bearing on the local government regulation of siting and planning. So wireless system architecture at a very high level, and what I'm talking about is cellular type systems, things used for communications between people. This is not broadcast towers or even the public safety systems, which I think, as Steve alluded to earlier, they're handled out of the different bureaus here, but the great majority of the facilities that are being built out, as far as number of facilities, are for the wireless communication systems. Those would probably be, nearly all of the applications that you folks will be seeing, although the tallest towers are for other purposes. At the most basic level, the way a wireless system works, there are radio waves that carry signals between the end user's device, the cell phone or smartphone or tablet, and a cell site antenna, which is what you see on the towers or on a building or a water tower or some kind of other structure. The purpose of the tower itself is just to hold up the antenna. The antenna is, what emits and receives the radio wave. And so, so that's the basic link between the phone and the system. Now, that's obviously not all that's involved in the whole system. From the cell site, the system needs to get to a carrier's central office, and this may be done either by means of fiber or by means of a microwave link. If there's a microwave link, that will require a dish to go up on the tower or on the building next to the antenna as well. If it is done by fiber, then the fiber needs to be in the ground or sprung up somewhere. And often fiber will get high capacity more economically than a microwave link. Not always, it all depends on the situation. But after that, at the central office, the call then gets delivered to the public network, eventually gets over to the other end of the call. If it's if it's a call to a wireless phone at the other end, then you go through the same sequence to the cell site and the device at the other end. If it's a wireline, it goes through wires. But one of the main points I want to make here is wireless does not mean no wires. The only part of a wireless call that is necessarily wireless is between the handset and the cell site. It's very rare to find a call that is not transported over some form of wire or cable at some point. I'm going to skip over a couple of things now and come back to the point in order right now. Apologize, this is taking a little while, but there we go. So just a little bit about how the cell sites work, why there are so many cell sites. As far as simply, sending signals out, if you didn't have a lot of demand on the system, you would need a cell site every several miles or so, which is where things were in the early days of wireless communication. Whoops, just went too far. There we go. But the reason that doesn't work is because of how many people we have using the system and how often they're using it, and the thick stuff, the high bandwidth that they're using for data applications and so forth. Each carrier has only a finite amount of spectrum because there's only a certain amount of spectrum available. And you can only accommodate so many users at one time. So if you have more users than that, the way to increase that generally, along with some more efficient technologies, is to make the cell site smaller. And what that means, instead of having one site covering a 5-mile radius, you would have 5 sites with smaller radii, or then from there on to 25 and so forth as you need them. And what happens then is in each cell site, the same frequencies can get reused. So you can have 5 different users using the same frequency where previously you could have only had 1. That's an oversimplification, but I think it's intended to get the idea across. As the cells get smaller, the antennas typically operate at lower power, and they're lower to the ground because not only you don't need the signals to go as far, you actually don't want them to go as far so that they don't interfere with each other. However, this also means that carriers have less flexibility as to where they can locate them. Skip over this slide as well and come back. So a couple of things going on. So that's the sort of the traditional cell site architecture. New developments, as we have broadband and increasing usage, are what we call small cells. And you may also see the term picocells or femto cells, which are types of small cells and not really necessary to distinguish between them. And largely what they do is really take the traditional cellular architecture and bring it down to a much more granular level, where you could have radius of the cell site of measured maybe in hundreds of feet or even less than that. They're used in both outdoor and in certain large indoor spaces to bring the, where the outdoor areas where there's a lot of usage and congestion, or in things like a stadium or convention centers. Sometimes it's the small cell architecture that will help accommodate lots and lots of users. They're sometimes used for small gaps in coverage, or they supplement service in limited areas where there's high demand, where there is some coverage, but it can't accommodate from the macro cell the demand that's there. Then we'll move on to distributed antenna systems, or DAS, which are kind of like small cells, but they take the concept a step further. A DAS is really, the best way to think of it is sort of an integrated system of many small antennas that are connected by fiber. And where these differ from small cells, in a sense, is that one difference is that one base station can serve several nodes. So, where there is a cell tower or something, there's typically an equipment cabinet of some sort at the base of it that has the equipment to operate it. When you get down to the DAS level, where there are things on every X number of utility poles or something, you don't necessarily need one of these with each node, each little antenna there. You can have one that covers several of them. Another nice thing about DAS is there's neutral host technology, where multiple carriers can share the same antennas, have their signals go over the same fiber between the antennas. We're used to sharing towers, certainly, but here it goes farther than that. And there again, there's both outdoor and indoor DAS. Outdoor DAS commonly are located on streetlights or utility poles. Indoor DAS applications include things like stadiums, hotels, shopping malls, office buildings. Now to give you just a bit of a picture of it. So this is just sort of an illustration of the many things interacting with each other. We have the macro coverage represented by the big towers here, and it could be a rooftop, could be a new tower, and these are all ways that you can improve coverage and bring broadband services around, wireless broadband. So sometimes it involves building a new tower or adding an antenna to a tower that's already there. It can help you just, even if you don't need to go to the smaller level of the small cells or DAS, you may need to add an antenna to a tower just because of the different technology that's involved, or in some cases even build a new tower. And then the other things are the outdoor and the indoor DAS systems, which can supplement the architecture that's already out there for broadband as well as for DAS. Just going quickly over sort of a little bit of review of something. So a different perspective on it. So what are some of the advantages of using small cells with DAS? All right. These small cell and DAS solutions can expand capacity by many multiples, more than just adding, splitting cells in the macro system. So, you don't need to keep on top of it and keep splitting cells as demand increases. One DAS or small cell build-out can cover future-proof you for at least, for quite a while. They create capacity for high-speed broadband data services, can be used to improve indoor coverage, and also the opportunity to share infrastructure. But a few caveats, these are not the answer to everything. They may not be economically reasonable in all circumstances, more rural areas, and, any number of other circumstances. It depends on a lot of things. Also, the small cells and the DAS typically supplement the existing macro network. They don't generally replace that. So once again, just another little overview. What are the reasons that we're having new construction going on One is, still increasing coverage, deployment to new areas that aren't covered yet. Not a lot of that, but in some rural areas, or fill in dead spots. Also, it's not just the first carrier to an area. We bring competition by bringing more carriers to an area. That they may need their own construction. Often they'll be able to co-locate on the first carrier's tower, but sometimes the tower wasn't structurally designed for it, or the way they have their network designed, the same locations don't work. But so I said filling in dead spots, also indoor coverage. Second basic reason is increase in capacity, either by the traditional splitting of cells or by small cell DAS solutions. And then the third reason for new construction is broadband services. I sort of went over this. I don't think. So, now what are the statutory provisions and regulatory provisions that relate to wireless facilities and local planning? I'm going to go through three things. First of all, there's 47 U.S.C. Section 332C7, which been part of the Communications Act since 1996. And you may be fairly familiar with that. There is the declaratory ruling called generally known as the shot clock ruling that interpreted Section 332C7 in 2009. And then more recently this year, there are provisions of the Middle Class Tax Relief and Job Creation Act. And so just a quick overview of each of those, starting with 332C7. The basic structure of Section 332C7, which you may also see sometimes referred to as Section 704 for reasons that matter only to the lawyers. It governs all personal wireless service facility siting. That includes new towers and co-location. And the general structure of it is that it generally preserves state and local authority over facility siting regulations subject to several specific limitations that are set forth in the statute. It does not address the allocation of authority between state and local governments. So if the state chooses to preempt localities and handle part of this at the state level, they may. They choose to let the localities do out of it. The things they may also. That 332C7 has no bearing on that. And another important piece of it is that if there are disputed cases for whether a local regulation complies with it, those are resolved by the courts. They may not be taken to the FCC, with the sole exception if there's an allegation that a decision was impermissibly based on the effect of radio frequency emissions. Those can be brought either to a court or the FCC. Just running very quickly, what are the limitations that 332C7 imposes? A state or local government may not unreasonably discriminate among providers of functionally equivalent services. Its regulations may not prohibit or have the effect of prohibiting the provision of services. Local or state government must act on an application to site facilities within a reasonable period of time, and I'll come back to that a little bit. Any denial must be in writing and must be supported by substantial evidence in a written record, and regulation of these facilities placements may not be based on the effect of radio frequency emissions to the extent that these emissions comply with the regulation. Now on to the shot clock decision. And the shot clock decision interpreted the provisions reasonable period of time and failure to act in Section 332C7. Again, that decision addresses new towers and co-locations. There's also a second part of the shot clock decision that's gotten less attention, but which resolved a conflict between the Federal Circuit courts in different parts of the country by offering some interpretation of what is meant by having the effect of prohibiting service. And the FCC ruled that this means that a local government may not deny an application solely because one or more carriers already serve a given geographic market. The shot clock piece of it, just going over what the outlines of that decision are. The FCC held that presumptively a reasonable period of time for a local or state government to act upon a facility siting application is 90 days if this application is for a co-location, that is locating an antenna on an existing structure, either a existing communications tower or a building, water tank, any other kind of structure, or 150 days if it involves construction of a new tower. And the Commission's reasoning there was that co-locations are unlikely to have significant impacts on the community, so those could be, one should expect them to be reviewed more quickly. And that was also based on, and these time periods are based on evidence in the record that most communities seem to, that these were well within the time frames that communities largely seem to be able to act on. If this period is exceeded, then by statute, an aggrieved party may file suit within 30 days. That 30-day period is actually set out in the Communications Act. We did provide the applicant and the government may agree to toll the period. There's no intent, if productive negotiations are going on, we don't want to force anybody into court. The presumption that the period of time was reasonable may be rebutted in court, so the government could introduce evidence that because of whatever set of facts here, the 90 days or 150 days is not reasonable and we should have more time. And then if the court finds a violation, it's up to the court to decide the appropriate. I'm going to very quickly go through these provisions of the Middle Class Tax Relief and Job Creation Act, which contains three sets of provisions that are relevant to co-location. There's Section 6409A involving local review of tower modification requests, and I'll spend the most time on that one. It's probably most directly relevant to you. 6409B and C, which talk about federal easements, rights of way and buildings, and there's also Section 6206, which talks about the use of existing infrastructure for a new national public safety broadband network. Provisions relating to federal lands, buildings, and rights of way. 6409B authorizes federal agencies to grant easements for wireless structures, equipment, and backhaul transmission equipment, and also directs the development of a common application form and fee principles. 6409C directs the development of master contracts and forms. I also do want to mention at this point Executive Order 13616, which came out in June and kind of overlaps with these provisions. What it did was directed the development of a strategy, and it's not limited to wireless. It covers both wireless and wireline. So it overlaps, but it's basically to promote broadband, help federal agencies bring broadband, and it established an interagency working group. The FCC is working with that working group. There's an initial report due in December, and then they're supposed to complete further work by next June. Also want to just mention that they also have responsibility for dig once strategies. That's also part of the executive order. And what these are strategies to enable when there is work being done on a road to get enough fiber put in to accommodate future users. And I'm sure many of you are working on those strategies in your own communities. The executive order is specifically focused on the federal angle of it, where there are federal grants for highway construction, to think about ways to work dig once policy into that, make sure that the federal policies are not unnecessarily obstructing dig once, and even to encourage policies that work for everybody. The next, quickly, the provisions on public safety co-locations. The statute established an agency known as FirstNet, which is in the Department of Commerce, as a nationwide licensee for a national public safety license. There are provisions directing the FirstNet to use existing infrastructure to the extent economically desirable, to use partnerships with commercial providers, and to consult with state and local jurisdictions on facilities placement. So these will all affect your work, I think, as this goes forward. The FirstNet board was named actually just earlier this week. You could find that by going to the website of NTIA, which is the agency within the Department of Commerce. Finally, 6409A, which is the provision that's more directly related to local regulation of facilities siting. And what it provides is that a state or local government may not deny and shall approve any application that's covered by that section. What does it apply to? It applies to co-location, removal, or modification of equipment on a wireless tower or base station. And it doesn't define what's meant by base stations, so some of that may need to be worked out. So it would not apply to co-location on something that's not a wireless tower or base station, whatever exactly a base station is. It also doesn't apply if the action will substantially change the physical dimensions of the existing tower or base station. But if it's within those provisions, then you're in this may not deny and shall approve. One of the questions under there, what is a substantial change in physical dimensions? just want to point out, and that has not been interpreted, but one thing that may be useful, which I think Steve may touch on a little more, is the decision, it's the provision in our nationwide co-location agreement for substantial increase in size, which we also used in our shot clock decision. That again, I'm not aware of any court decisions at this point interpreting. There are no official FCC interpretations, but that may be of some kind. And what this substantial increase basically provides is there's a substantial increase in size if there's an increase in the tower height of more than 10% or the height of an additional antenna array plus 20 feet, more than 4 new equipment cabinets or 1 shelter, a protrusion of more than 20 feet or the width of the tower, or excavation outside the existing lease-owned property. Administration of 6409A, it takes precedence over 332C7 in the event of any conflict. It would coexist with 332C7 if there's no conflict. And finally, there is a provision it does not affect the FCC's responsibilities under NEFA and the NHPA. I think in the interest of time, I'm going to go past this one, which is basically a review, and then I will hand things over to Steve.
Thank you, Jeff. Shift the machine this way a little bit. Okay. While I tee up my slide and all the pieces, one of the things that we have talked about is new towers. You should be aware of the fact that the cellular communications companies have been real busy the past several years building out for the increased demand for the use of cell phones, for smartphones especially, and for 4G and LTE. Our records indicate that over the past 2 years, the wireless communications providers have been proposing between 10 and 12,000 new towers a year. So as local planners, if you have regulations that impact on the siting of communications towers, you should be busy with them. I know my community is. So with that, what I want to talk about is some of the things that apply to the work that I do for the siting of new towers. And while I'm the only federal preservation officer here, I work with a group of attorneys that provide assistance in some of the legal aspects of tower siting. All new towers must comply with the federal environmental regulations, which includes Section 106 of the National Historic Preservation Act, the National Environmental Policy Act, Endangered Species Act, FEMA floodplain regulations, Army Corps of Engineers, wetlands, and those kinds of things. You should also be aware as local planners that all of our environmental compliance regulations involve public notice, and we very much intend that our applicants and the consultants who often work for the applicants in getting towers built, whether they're attorneys or engineering firms, include public comment in the tower siting processes, at the federal level at least. Most of the public involvement is done through the Section 106 historic preservation process, which is a federal level regulation. We require all of our licensees for new towers and for co-locations to require it to do some form of local notice. Generally, the people who do the siting do that as a legal notice in the local newspaper. It doesn't have to be that way. There are some communities in certain parts of the state where there are no, or the country where there are no newspapers, and what constitutes local notice for those particular counties is a notice pasted on a bulletin board by the courthouse door, and we sort of go along with that because that's the tradition in those communities. If there are questions, then people can call us, and I'll mention this at the end. I'll mention it now while I'm thinking about it, is that if you have questions on the things that we've been talking about this afternoon, my contact information is at the end, and I thought it was easier just to have a single point of contact at the FCC for all of your questions, and I will make sure that questions that you have get to the right person within the FCC. But I wanted to make sure that you all understood that we do firmly believe in the public input process. The other piece of that is with the radio frequency aspects. New towers or licensees and co-locations can't interfere with somebody else's use of that spectrum. Section 106 of the National Historic Preservation Act requires federal agencies to consider the effect of federal undertakings on properties included or eligible for inclusion in the National Register of Historic Places. These are things such as historic districts, downtowns, historic neighborhoods, farmsteads, mining sites, railroads, bridges, a wide variety of things can be on the National Register of Historic Places. And the National Historic Preservation Act further defines what an undertaking is, requires a federal permit, a license, or approval. Our licensees are our licensees. We regulate what they do. The act of that regulation requires the permitting. One of the things that is an interesting piece of that is that there are a lot of companies out there that are in the business of building towers on speculation. And then they go out and attract our licensees to locate on their towers. So that you may have encountered some of those in terms of your local zoning work. We are more concerned with what our licensees are doing than those towers, but since they all work together, it works out to be a fairly common system that is fairly easy to understand. At the FCC, we have defined the undertaking as anything that includes things associated with that tower construction. So that for the project is the tower, the fence, equipment sheds, access roads, power, fiber optic connections, other kinds of things. Reading from the bottom to the top. Those things are in our environmental regulations, and there's a citation if you would like to have that. And while we as the federal agency are ultimately responsible for the Section 106 compliance process, that historic preservation review, we do rely on the state historic preservation offices in each state and the District of Columbia and the territories. Those are the SHIP offices, a term you may have heard occasionally in your work. They do much of the ordinary review. So of the 10 or 12,000 projects a year, we see the ones that become most difficult and contentious. By and large, at least at the federal level, outside your local zoning processes, these things tend to be fairly non-controversial. And we always try to remind our licensees, because every once in a while they forget, especially those that don't build towers very often. The height of the design of the tower is not relevant in determining the proposed tower is subject to Section 106 and NEPA. The grant of a license, if you have a geographic license to build a tower somewhere in New Hampshire, that doesn't give you permission to actually construct the tower. And then applicants are required to involve federally recognized tribes in the review process. And as local planners, one of the things that sometimes happens, or local engineering firms too, is that the tribes that might be concerned about a particular tower are not necessarily resident in the local area or even in the state. They may have been removed at one point or another. By and large, as mentioned earlier, the tower projects tend, from a historic preservation standpoint, to avoid directly impacting or adversely affecting those historic districts and landscapes. Most of the commercial carriers have gotten real good at trying to avoid those kinds of things. Occasionally they have to. And when that happens, and there is an adverse effect on one of those historic districts or a landscape, old church, farmstead, etc., those projects come to the FCC, to myself, and at least one of the attorneys who's working on that. An adverse effect on the historic property does not stop the project, but it gives it pause until we go through the process. When there is an adverse effect, we make the applicant submit an alternatives analysis. Where else could that tower be located, which is what we mean by alternatives analysis, and a mitigation plan. What are they suggesting to mitigate the effect of that tower on that historic property? The applicant is required to involve the local community in determining appropriate mitigation measures. We've been involved in numerous negotiations between the community, whether it's by advocacy groups or neighborhood groups, or whether an organized involvement of the jurisdiction through a local planner and the applicant to develop mitigation measures. We encourage that sort of thing. It's hard sometimes here in D.C. to decide what's appropriate as a mitigation measure for a tower project in South Dakota. So we rely on the local community to do those. And then the mitigation measures must be directed at the impact of the historic property, so that we don't want the mitigation measure, whatever it is, to benefit the historic property that's 10 miles down the road. And we're sort of running out of time. Some of the suggestions we have for mitigation measures: lower the tower, reduce the size of communications gear, paint the tower and gear. That can be real difficult in some mountainous areas where color change as you go up the tower. Install a stealth tower. You may have seen monopines, plantings around tower bases, and then have some sort of benefits from the historic property. And benefits to historic properties can be preparing national register nominations, do a halves or hair documentation, photographs, measured drawings, do signs, brochures. We like things that have public benefits, so signs, brochures, cell phone tours. Our favorite mitigation measures here, at least with me at least. And then we encourage everybody to work with the SHPO and the community to develop those preservation needs. There's some useful websites for you all for some of our regulations, and these will all be on the site, the archive of this. And then some additional steps. We've been doing a lot of educational programs. In addition to this webinar, we've also been holding sessions here at FCC headquarters on DAS small cell solutions, co-locations. The videos of those are on our website at that address. For the fall, we're planning at least 2 sessions here at the FCC, one on the technology of wireless communications. We're also going to be holding one that is for our licensees and consultants that will address some tribal issues that have to do with tower siting. And then let me get my full contact information. If you have questions, contact me here, and I'll make sure that the right person at the FCC gets your information. And for logistics, email works best for me, because I can send the question directly as you ask it to the appropriate person. So with that, I think, yeah.
If I can just add one other quick thing in terms of resources that we have that we hadn't mentioned. The FCC also has an intergovernmental advisory committee consisting of representatives of state, local, and tribal governments. We work very closely with them. They make recommendations to us. They're very engaged in these infrastructure issues. And again, you could find the membership of that on our website. So that they may be someone else you may be interested in talking with.
I believe that organizers of the programs probably have some questions that people would like us to answer.
Yeah, now we'll have a question and answer time.
Okay.
First question is from Doug. Are there any programs which could assist to reduce the cost of burying overhead wires community-wide?
I don't think so, unfortunately. You
Okay.
know, and there's not even much more that I can say about that. I mean, I know that often there are, you know, sometimes local areas have, for example, in the cable franchising agreement, you know, or the cable ordinance, there may be provisions in those type of documents that relate to, you know, how costs be allocated for undergrounding and things like that. But the FCC, to my knowledge, doesn't have any programs about that. And primarily just at a high level, the the main reason for that is that because we deal with just interstate communications and inter overseas type communications too, that the sort of the cost related to the movement of local facilities underground really isn't a federal concern. It's more a state and local concern.
What else do you have for us?
Okay, the second question is from Ryan. Verizon is planning to get rid of DSL service in rural areas as they roll out more 4G LTE. What are the implications of this planner in these communities, and especially as 4G LTE is very expensive, and they have also recently made large deals with other options, cable service providers?
I think, yeah.
Well, that is an issue we are looking at. The commission is, our highest concern these days, especially on the wireline side, is with broadband deployment and ensuring that all Americans have access to broadband. So we recognize that, some providers have, not found it in their interest to continue providing DSL services. I know Verizon recently changed the terms of its DSL offerings, and it's no longer offering standalone DSL. And you made reference, or the questioner made reference to the Spectrum Co deal, which is the Verizon Wireless. The transfer of spectrum from a collection of cable companies to Verizon Wireless, and in association with that, some joint marketing agreements and a technology venture. The commission took a very close look at that transaction or set of transactions, along with the Department of Justice. You probably have seen the trade press on that. So anyway, it's it's an issue we are concerned about. We're looking at. I don't, there's nothing, I can say really beyond that at this point, I guess.
Okay, the third question is from Mike. Since a municipality cannot deny an application from a carrier under the Middle Class Tax Act, why didn't the FCC implicitly preempt the need for public hearings, etc.? It seems that under the regulations, only administrative review should be necessary along with a building permit, and he is a zoning representative in the wireless industry.
Okay, well, I can take that one. The FCC has not acted in any way to interpret the terms of Section 6409 of the Middle Class Tax Relief Act. I think that the interpretation that was proposed there is a possible one. It's reasonable to think that that procedures should be proportionate to the types of powers that a local government has substantively. But on its face, the statute, as you know, speaks substantively to may approve and shall not deny. These things would have to be worked out. As the law is developed, I expect that the principles will take shape as to, exactly what the provision means.
Okay. This question is from Scott. You said that the height of the proposed tower has no bearing on NEPA review, which federal regulations address potential impacts from increased tower height or the proposal of a tower which significantly exceeds community standards. Here I'm thinking that a taller tower implies a greater fall zone, which in turn implies more potential for environmental impacts.
We don't rate. We're not in the business as a federal agency in determining fall zones and whether communities need to have fall zones. That's a local decision.
If I can address that piece of it at least. Structural safety regulation is up to the local government, and that would include anything for fall zones, again, provided that the regulation is done in a manner that's consistent with Section 332C7. Fall zones could not be enforced in a manner that prevents service from being provided. But within that constraint, and certainly ensuring that the structure is safe and complies with standard codes. That's a local government responsibility.
There are codes that have been developed on a nationwide basis for communication towers, but that's not something we usually get involved in.
Okay, this question is from David. You talked about licenses, but how do you regulate unlicensed providers?
Unlicensed providers are actually handled by a different bureau within the Commission, our Office of Engineering and Technology. But generally, the FCC's regulations, provide that certain types of transmissions do not require a license. They just need to comply with certain rules, particularly involving low power, which spectrum bands they're allowed to operate over, and they're not allowed to cause interference with licensed operations, and need to accept interference from licensed operations that are, if someone's operating within the bounds of their license, the unlicensed provider can't complain that they're being interfered with. Given that, they're sort of, free to operate within those constraints, and subject to enforcement actions if they violate those constraints. And our view is that an unlicensed operation, since there's not a license involved, that those are not required to comply with our Section 106 and other environmental regulations, other than the RF safety, the exposure to the emissions.
Okay. This question is from George. Are there FCC regulations for arrays and distance from the pole?
Sure. Can you repeat that question?
Are there FCC regulations for arrays and distance from the pole?
Okay. You mean the communications arrays on a communications tower and distance separation?
Oh, vertical separation. Maybe that's what they're.
I think so. Generally, the commercial providers have sort of more or less decided on their own that there needs to be at least 10 feet between each of the platforms or the arrays, as the term the person's using, so that we do encourage co-locations on towers. We're trying to discourage people from building new towers right next to each other, so that, and most of the new towers are designed to, and these tend to be the ones that are under 200 feet that most of you see that don't have lights, to hold 3 to 5 different co-locations, different carriers or different arrays.
Yeah, this question is from Robert. Do you know any examples of hybrid systems with a combination of cell towers and DAS systems?
Well, I mean, certainly carriers, as part of their, as part of their system, pretty much any carrier operates from a combination at this point of both, other than maybe in very rural areas where they only have the traditional cell sites. But, certainly the major carriers have both. Within individual communities, they have both. They interact, they speak to each other. They pretty much have to in order for the system to function. So, so I think the answer is that, in some sense, every system is a hybrid. I'm not sure there really is such a thing as a standalone DAS, and at some point it does relate to the macro system.
This question is from Laura. We have been told by the FAA that it is illegal, according to FCC regulations, to both light a tower and paint it. Is this true?
Any individual tower should be lighted or painted, must be lighted or painted in accordance with the specifications by the FAA, and we require compliance with what the FAA has specified. I can't say for sure whether there are situations in which the FAA requires both painting and lighting. I believe it does, painting for day and lighting at night. In most instances where there's painting, there are no lights during the day, but there are lights on during at night. I'm not an expert on all the details of the FAA regulations, but whatever it is that the FAA requires in its specifications, we will then ordinarily enforce that.
Okay, this question is from Amelia. Do you see substantial change and significant increases as two different things?
I mean, they may or may not be. Congress, for whatever reasons, chose to use different language. So therefore, that does pose the question, does it mean anything different? If it does mean something different, there is no indication anywhere in the legislative history of exactly what it means. But that's something that's probably going to have to be worked out through the court system, or if there is a petition to the FCC, then we would address it as with any of these issues of interpretation. At present, and this could be subject to change, but at present there are no immediate plans on the part of the FCC to on our own initiative take any action to interpret the terms of that statutory provision.
Okay, this is from Nikki. Is co-location required on a tower? Tower located within the railroad right-of-way, ostensibly for railroad operation purposes under 49 U.S.C. 10501?
There are no provisions, at least as far as federal law, that require co-location. We would encourage railroads to permit co-location, as we encourage other tower owners to accommodate co-locations on reasonable terms. And of course, there would be a benefit to the railroad tower owner then in terms of revenue coming in from that. We don't have any kind of regulations that would require it. There could be. I know that local jurisdictions often, as part of zoning approvals, will require that the tower owner accommodate co-location.
Okay, this is from Daniel. Could you mention about the tower construction notification system?
Okay. The tower construction notification system is the system. It's an electronic system that the FCC developed. It's the only one like it in the federal government that provides notice to federally recognized tribes. All the 566 federally recognized tribes participate in it. What they have done is identified to the FCC those counties in which they are interested, and because our licensees are required to provide notice to the tribes whenever they're trying to construct a tower, this makes it more efficient. Tribes they actually receive a notice every Wednesday of all the towers proposed in the counties in which they're interested, and they can respond back to the electronic system. So it makes it efficient, and that's all that it's used for, is the tribal notices.
This question is from Robert. In view of potential storm events, do you have any plans for regulations on emergency power backup?
That's something that the Commission is considering. Nothing more than that I can say about it.
Okay, this is from Shannon. Our zoning ordinance limits the number of antenna per structure to 3. Structure can be defined as tower, array, building, etc. Any structures with more than 3 antennas have required a zoning code variance. Does this limit run afoul on a FCC regulation?
I mean, again, that's a question that a court would have to decide. I think the argument, if somebody were to challenge it, probably the most likely argument would be effective prohibition of services under Section 332C7, and I think that would, that may end up being a fact-specific inquiry.
Okay, I think that's it for the questions. So thank you very much for your presentation, and thank you all for participating for today's webcast.
Well, thank you for allowing us the opportunity.
All right, thank you.
Bye.
For those of you who are still in attendance, I just want to go through a few reminders. First, go off to log your CM credits for attending today's webcast. Please go to planning.org/CM, select today's date, August 24th, and then select today's webcast. This webcast is available for 1.5 CM credit. Also, we are recording today's session, so you'll be able to find recording of this webcast along with a 6-slide per page PDF at utahapa.org. This concludes today's session, and I want to thank everyone again for attending.